Mr. Speaker, I had previously spoken about our nation's bankruptcy regime in the context of the 2020 amendments to the Insolvency Restructuring and Dissolution Act, or IRDA. The bill that is currently being debated seeks to render permanent the centerpiece of the previous amendments, the Simplified Insolvency Program, or SIP. Along the way, it further streamlines two parts of the SIP, namely the Simplified Debt Restructuring Program, or SDRP, and the Simplified Winding Up Program, or SWUP. As Minister Tong has already elaborated, these include a number of appealing and commonsensical refinements, such as shortening the moratorium period in the SDRP, limiting the eligibility criteria to just one for SWUP, and reducing the number of required supporting documents for both processes. Today, in addition to touching on three elements in the present bill, I will also address two broader concerns that align with the spirit of the issue. First, how much bang for the buck we are truly gaining by further simplifying corporate bankruptcy in this manner, and second, whether there's a pressing need to also consider whether individual bankruptcy proceedings can be simplified more as well. On the present bill, I will note first that Clause 38 will now require the notification of the dissolution of the firm to be published on the designated website only, without also doing so in the government e-gazette or newspapers. The permanent record will also be available on ACRA's BizFile. This move is, as I understand it, an effort to reduce the costs of the new SWUP. While I understand the motivation to reduce costs, especially for newsprint, I wonder why the publication on the e-gazette, which should be the most complete official journal of the country's public and legal notices, is precluded. After all, notices there are already electronic in nature, and a half-page entry costs a little more than $100. If this is prohibitive, perhaps a waiver or fee reduction can be considered for such instances. Second, Clause 20 shortens the moratorium period from 90 to 30 days. This justification appears to be a desire to strengthen creditor rights. The natural question here is if this 30 days is reasonable and sufficiently balances creditor protection with debtor difficulties. Would the government be willing to share with this House the historical mean and median times for restructuring plans to be completed in Singapore? If it does not have this information, how was the decision to reduce the moratorium from 90 to 30 days ultimately arrived at? Third, Clause 16 now requires only a supermajority vote of 2/3 of the creditors for the DRP to be approved and binding for all creditors. This is a seemingly simple but important step to ensure that restructuring can proceed expeditiously without one or two low-key creditors preventing an efficient resolution of the debt. This so-called holdout problem has been an affliction, especially in sovereign debt restructuring instances, and has led to significant problems due to the presence of so-called vulture investors. This move essentially embeds a collective action clause as a means of ensuring post-default resolution, and is one way to usher negotiations or renegotiations to a close. While I do not necessarily disagree with the approach here, I would like to know if the 2/3 majority will be weighted by each creditor's exposure, since I believe that this would be fairer than a one creditor, one vote system. I would also add that another way to try to bring about the outcome is through exit consents. These allow the majority to alter the non-financial terms of the debt in a way that would make the debt shares of holdouts effectively worthless. This strategy may be even more preferable insofar as ensuring that even initial holdouts ultimately deliver a consensual, even if acquiescent, vote, rather than one where the supermajority alone may ram through their preferred outcome. In my earlier speech on the 2020 IRDA amendments, I had expressed my support for less onerous, appropriately designed resolution procedures, since doing so will have helped bolster a more entrepreneurial mindset, especially in a knowledge and information-driven economy. This was especially important then, when the shadow of COVID-19 and the associated spike in business failures may have led to heightened risk aversion among small business owners. Yet, over the intervening 4 years, the record on the actual usage of the SIP does not appear to suggest that the issue addressed by the SIP were major binding constraints. The total number of applications for the SIP, as at the end of October 2024, amounted to 116. Given the total number of bankruptcies since the SIP came into force, this is a usage rate of about 1 in 10. Admittedly, the SIP applies only to small and micro enterprises. But given how 2/3 of companies in Singapore are actually small firms, and how small firms are typically much more likely to fail, this does not seem to be too poor an estimate. Now, if indeed the need for simplified insolvency is so pressing, why would the take-up rate be so limited? Now, this is a more general point. According to the World Bank, the strength of Singapore's insolvency framework scored 74.3 out of 100 in 2020, placing it 27th in the world. While this may suggest ample room for improvement, the reported weaknesses had little to do with speedy bankruptcy resolution or high costs, both of which our nation ranked among the best worldwide. Rather, they relate more to the management of debtors' assets, limited creditor participation, and the poor involvement of creditors in reorganization proceedings. Future revisions of the corporate bankruptcy framework may wish to bear these lessons in mind. Now, to be clear, any reduced cost of doing business for our small and medium enterprises are welcome. Still, one is left to wonder if we are focusing on meeting a genuine business need with the SIP or dancing around other insolvency concerns that may matter more. This is especially relevant when one considers how, over the same period, personal applications for bankruptcy were an order of magnitude higher, amounting to almost 15,000 cases. Applications hit an 18-year high in 2023 and are on track to significantly exceed that number in 2024. This begs the question then of whether the resolution regime for individual bankruptcies can be further expedited and simplified, much like what we are doing here for companies in this bill. Doing so may even improve our business climate, since the nature of entrepreneurship today is that many individuals take on personal debt to pursue their dreams of starting their own company. To be fair, there have been some advances on that front. Debt repayment scheme, modeled after Chapter 13 of the US Bankruptcy Code, offers a debt resolution alternative that is more flexible and forgiving than traditional bankruptcy, at least for debts below a certain threshold. But after more than a decade and a half, the DRS appears to be fraying at the edges. As my Sengkang colleague Louis Chua recently pointed out, third-party consultants are being engaged to help with the administration of the program, and the fees they charge may be a concern. Yet the Ministry of Law does not regulate third-party debt consultancies or the fees that they charge, which potentially allows such consultancies to take advantage of distressed Singaporean borrowers, thereby worsening their debt burden at a time where they least need it. While it is undeniable that there should be some nominal fee for the administrative costs incurred by the official assignee, or OA, the 1.5% collection and 3% distribution fees by the OA may be seen as punitive, especially if the debt amount turns out to be rather significant. DRS hearings also currently exempt creditors from attendance, which may introduce inadvertent delays in the process of discharge, especially in instances where the repayment schedule also needs to be renegotiated. In addition, Singapore remains somewhat of an outlier among advanced economies, where there is no automatic discharge from bankruptcy. The United Kingdom wrote this out in its Insolvency Act of 1986, while Hong Kong did the same at the end of the 1990s. Germany and France followed a few years after, and even neighboring Malaysia started in 2017. Moreover, even the elapsed duration before a discharge may even be considered by the OA here is a long 3 years. Contrast this to Canada, where the duration for automatic discharge is 9 months for first-timers with no surplus income and 24 months for second-timers. Or the United Kingdom, where bankrupts only have to wait for a year after the order is first issued. Or the United States, where debts under Chapter 7 bankruptcy occurs 4 months after filing. So, while automatic discharge and expedited exit from bankruptcy must not be regarded as a magical panacea for encouraging risk-taking and entrepreneurship, it nevertheless underscores how a more consumer-friendly regime seems to be warranted, especially since we are doing so for businesses. Surely we do not wish to leave tens of thousands of Singaporeans in debt purgatory for longer than they need to be. It may also be time to revisit the bankruptcy threshold, which is currently set at a fairly low level of $15,000. This was last raised in 2015 from $10,000. However, taking inflation into account means that would be equivalent to about $18,000 in today's dollars. Notably, the threshold was also temporarily raised in the aftermath of the pandemic to $60,000 and accompanied by an increase in the eligibility threshold for the DRS to $250,000. While we are here debating a permanent extension of the pandemic-era accommodations for corporate bankruptcy, I would urge the ministry to also do the same for individual bankruptcy. Now, the possibility that we face a tide of even more personal bankruptcies in the year ahead is very real. Rising costs of living have placed immense pressure on many households. Retrenchments spiked in 2023 and are likely to remain high for 2024. And interest rates on debt worldwide, including Singapore, have remained stubbornly high even after the more recent rate cut cycle by the US Federal Reserve. This portends yet more challenges for Singaporeans who are struggling under the burden of debt. Hence, while I support this bill, I urge the government to also consider analogous improvements to the insolvency regime that applies not just to firms, but also for our households.